Hello, everyone. My name is Valerie Manu, and welcome to today's webinar, briefing on the new Department of Labor and Industry Workplace Standards. Before we get started, I'd like to go over a few items so you know how to participate in today's event. When you join today's webinar, you selected to join either by phone call or computer audio. If for any reason you would like to change your selection, you can do so by accessing your audio pane in your control panel. This webinar is being recorded. We will share the recording and the PowerPoint with webinar registrants after this session. All participants are placed on mute for quality assurance. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions pane of the control panel. You may send in your questions at any time, and we will collect these and address them during the Q&A sessions throughout and at the end of today's presentation. And now I'll turn it over to Kathy Glazer, BCF President.
Thanks so much, Val, and good morning, everybody. We're really glad to have some time with you today to share some really important information. Just a quick look at our agenda today. We'll get started with some opening comments from Megan Healy, who's the Governor's Chief Workforce Advisor. We will then have an overview of the Department of Labor Workforce Safety Regulations by Courtney Malveaux with Jackson Lewis, PC. And then we'll hear some comments from Jenna Conway, the Chief School Readiness Officer, and leave plenty of time for questions throughout. And so as we get started, I will welcome Megan and really appreciate your coming on board to give us some perspective from the Governor's office.
Great. Well, thank you so much, Kathy, for having me on this call. I am in and out of meetings all day, so happy Friday to everyone. Also want to thank Courtney Malveaux, who's done great service on our Safety and Health Codes Board, really leading the charge and really working through these emergency temporary standards in support of Department of Labor and Industry, so I really appreciate that. You know, the Governor, we've heard multiple complaints, many thousands of complaints about workplace safety, that people are scared to go to work, and so really bringing these standards forward was really important, and it's really around workers and making sure that they do feel safe, because to open the economy, the first thing we have to do is make sure people do go back to work, and we're trying to do as many things as we can to make that happen. So, because we know this health crisis is going to turn into economic crisis, and that's might be our hardest challenge. So I really appreciate it. I do want to say that with many conversations with Department of Labor and Industry, that we really want it to be not as a stick, but how do we build partnerships with business to make sure they're in compliance? It's really about reaching out. If you go through these emergency temporary standards and some of it are scratching your head, or that you might need help with compliance, we really appreciate if you reach out to Department of Labor. There's a consulting arm. Talk about your issues, talk about your problems. We had many businesses already do this, about interpretations of what does this mean, how does this affect my business, and we're really trying to be helpful, because we want everyone to be safe, all our workers safe, and so really trying to do that education, that outreach. You'll also know about what's provided on the internet, if it's for training options, if it's for infectious control, preparedness and response plans. Those templates is all can be found. So if you have any questions or you're finding additional challenges, please reach out to Department of Labor and Industry. You can reach out to my office, reach out through Kathy, and we can sit down and discuss some of these issues. We are with many other industries as well. And secondly, that I just want to mention is next week we do have a special session. And so other additional worker issues are coming up if it's around immunity. And immunity could be for the teacher. If an example is if a teacher is asymptomatic and gave a child COVID-19, that there would be a level of immunity, I guess it's limited immunity or liability for that to cover the teacher. So we are looking at that. I'm not sure what the bills look like, but we've talked to a lot of legislators around that. There's also some bills floating around about workers' compensation and presumptions that teachers might, if they do get COVID, might have a presumption for workers' comp. And so there's going to be a lot going on next week that we are going to, again, make sure that our workers are safe in this COVID-19 environment. So we'll keep you posted on that. But I really appreciate everyone jumping on this call. I have a 3-year-old who is now down the street from me in a child development center who stayed open this whole time. And the precautions and the extra mile they've taken for their workers to be safe, but really the children to be safe is above and beyond any expectations that I ever, and I'm just really appreciative of all the things that you do. We need you. We need these services for our workers to go back and feel comfortable going back to the workplace to get our economy. And then one day, hopefully, we're going to get over this COVID-19 situation. But I really appreciate all the work that you guys are doing on the front line. Many people appreciate that. So thank you very much.
Megan, thank you so much. We really appreciate your taking time to jump on and share your comments, and especially appreciate the personal note. We'll let you get back to your meetings, but it was really helpful just to hear that sort of broad overview of what's going on. And thanks so much, Megan. Best to you and that little sweet 3-year-old.
Thank you.
Next, we are really pleased to have Courtney Malveaux, who is beaming in from a work trip in Roanoke, and we really appreciate him stepping away from his regular duties to provide some information. Just wanted folks to know, Courtney, that you're a principal in the office of Jackson Lewis, BC in Richmond. Your practice focuses on representing employers cited by the Occupational Safety and Health Administration and other regulatory agencies, often following catastrophic incidents. Mr. Malveaux advises and represents employers in employment law matters, business associations, and state and federal legislative and regulatory matters, and has testified before congressional and state legislative committees on workplace safety and health matters. And really appreciates the fact that prior to joining Jackson Lewis, Courtney served as commissioner of Virginia's Department of Law of Labor and Industry and as president of the National Association of Government Labor Officials. So with all of that pedigree, Courtney, you're the perfect person, I think, to review the regulations and the implications of the regulations for childcare providers, who I think we've all, kind of distinguished as a medium risk organization. And as we get started, Courtney will just welcome you and express gratitude, and also ask you if you wouldn't mind, sort of at the top, share a little bit. I found our conversation yesterday so helpful, and the perspective that you bring about how we think about mediating risk in this environment. Would love you to start with some of those thoughts for our audience today.
Well, thank you, Kathy. I appreciate that. And by the intro, I sound busy. As a matter of fact, I feel pretty busy. So I am on a work trip in a hotel room at this point. And so, yeah, I think I responded to you yesterday really more as a dad. I'm also a parent. I have a 10 and a 12-year-old, 2 sons, and definitely remember the experience of having them, the years of the childcare and working with that well, and work down the street. And so I really appreciate what you all do to care for our children, and including mine. And so it would be a real kick if our care providers were on this meeting. I would love to hear from you. So thank you all for what you do. And so in the environmental health and safety circles, what we talk about is not necessarily avoiding risk, because this is a pandemic. Pan meaning everywhere, affecting everyone. And so it's something that you can't really fully avoid, but you do talk about managing risk, because if we're going to be in this for the long haul, and what looks like we don't have a choice for at least a longer stretch of time than initially we thought, then we have to really approach this in terms of embracing the fact that, okay, there's going to be risk for all of us. It's going to happen. How do we manage that? And so we try to make small decisions along the way to make sure that we are managing the risk as well as possible, and reducing as much as possible for ourselves, for those we work with, and for those that we care for. And so that's all of us. That's me, and that's all of you. So right now, as Megan mentioned, there's a standard that has been put through by the Department of Labor and Industry, and so it's new, and it has some new requirements, some things that you may not be familiar with, and so I'd like to take this time to kind of walk you through that. So, Kathy, should I go ahead and jump right in? Okay, it sounds like I probably should.
Yeah,
right.
That's right. Thanks, Courtney.
Okay. In the law, silence usually means dissent. So, all right. So what I'll try to do is walk you through what is, so Virginia, I'm going to talk a little bit about what the new standard is, how we got here, and I'll talk about what the requirements are for all employers. And there's some of you who may have some low hazard job tasks and then some medium hazard. And I'm going to, if they'll allow me, I'll be glad to make this available to you. I know this is recorded, but also if you'd like a copy of my presentation, if it's a good resource and a good reminder of what we discussed, then absolutely. So I'll talk about the background of it, then I'll talk about the requirements, and then along the way, I'm glad to take questions along the way. This is your time, it's not mine. I like to have discussions instead of presentations when possible. And but I'll leave some time at the end for questions and answers as well. So could we go in advance? So here's a quick background on the emergency temporary standard. Let's go in advance, please. All right. So we're familiar with the Occupational Safety and Health Administration. Many of you are OSHA, and so it ensures safe workplaces nationally. And so there are some standards there that we've operated under, and also there's what's called a general duty clause. And basically that is in the federal law that says that employers have to have, they have a general duty to make sure the workplaces are safe to recognize hazards. And so this pandemic came up, you know, there are standards that have been in place for 40 years. Nobody could have imagined this. This is a novel coronavirus by definition new. And so none of the standards that exist address where we are. And so, you know, we do have a general duty to keep our workplace safe, but, you know, we need a little bit more than that to go on. So that's how we got to where we are. Could you advance for me, please? So Virginia is one of about half the states where, okay, there's federal OSHA. Well, we operate our own OSHA program here in Virginia. And so we call it Virginia Occupational Safety and Health. And so VOSH, when I say VOSH, or it's within the Department of Labor and Industry, DOLI, when I talk about VOSH or I talk about DOLI, I talk about our OSHA program here in Virginia. And so it applies to all of you. The only exceptions are when, you know, if any of you happen to work in a federal workplace, or then we're not talking about this standard. But this standard applies to private sector employers. It also applies to state and local employers. So I think this is going to apply to all of you. Could you advance for me, please? Okay, so to address COVID-19, because the law that we've had doesn't really address it, we do have guidance that has come from OSHA. We also have guidance that has come from the Centers for Disease Control, and many of you have probably seen a lot of that in the press. And so they've been really trying, as the science is evolving on this, as we're learning more about the coronavirus, the CDC and OSHA have come up with guidance documents saying, well, you know, we think you should do this, we think you should do that. And that's going to continue to change because there's a lot we still don't know about the coronavirus. But what VOSH did, I sit on a board. There are a lot of citizen boards in Virginia, a lot of boards that people can volunteer to be on. I volunteered to be on this board. And so this is a board, the Safety and Health Codes Board. And basically what we do is we pass OSHA regulations in Virginia. And so we passed one on COVID-19, on the novel coronavirus. That just happened on July 15th. It just became effective on July 27th. And so right now what the agency and a lot of employers are doing is we're just kind of moving through this new standard, trying to figure it out and trying to make it work in workplaces. And so hopefully what I'm trying to do is, as a member of the board, but now as an attorney, I'm trying to help employers to understand it, help to comply with it, and try to make as much sense of it as possible. Now, just by way of background, this new standard is temporary. It's not going to live on forever. In fact, it will expire on January 26th, or if the governor's state of emergency expires. I don't expect to see the governor's state of emergency and coronavirus expire. I don't. That's my personal opinion. And so I think this is going to be with us. But the board is actually looking at a permanent standard that will go on beyond January and for the foreseeable future. So there will be some tweaks and changes, I think, in that permanent standard, but I'd like you to at least get your feet wet with the standard, the temporary standard we have through January, because it's really going to carry you through the next few months. Could you advance the slide for me, please? All right, so let's talk about what's in the standard. What does it require of everyone? Let's advance, please. Okay, so the way the standard is structured, as I kind of suggested before, so there are low hazard employers or job tasks, there are medium hazard, there's high hazard and very high hazard. And I think by and large, people here are going to be in that lower medium, in those lower medium categories. So I'm going to emphasize those, but I'll leave you a little bit of information about high and very high, just in case you have folks who fall under those categories. So it requires, and this is you as an employer, this is what's required of you. And notice, so we focus a lot in terms of the safety of our clients, and that's critical. OSHA is really about workplace safety, protection of those who work at your workplace. So while I may not address much by way of child safety, this law really addresses worker safety. So that's what the focus of this law is. Of course, there are child safety requirements in law and standards elsewhere, but right here for this is about worker safety. So you have to have some policies and procedures for employees to report symptoms, and especially if you're in a smaller workplace, just letting folks know, hey, this is the person you come to if you feel like you're sick or if you think you have COVID. You, of course, are supposed to, when you learn that someone has COVID, you are supposed to either prevent them coming onto the workplace, or if you try to get them out of there as quick as you can, so that before they spread it to other people. There's a requirement also in terms of flexible sick leave policies. The standard doesn't really define what flexible means, and I think what it really means, if you try, I know that, look, you have your caregivers, you have administrators, you have people who have to be there, you have to cover for each other, and so if someone gets sick, how can you just kind of move people around and shift people around to cover what you need to while letting a person have the time they need to get well? I think that's what flexible means. And I think that really depends on your situation. I mean, if it's 5 or 6 people working together, that's a lot of flexibility. If you're talking about a center with dozens of people, then it's easier to be flexible. I think it just really depends on your workplace, just making an attempt to be as flexible as you can with your employees to help them to get well and get back into work while keeping other people safe. So you have to have a system to receive reports of positive tests from your employees. And this includes any temporary employees. This includes any contract employees. And also if you have other contractors who work there. I don't know if maybe you have a cleaning staff, or maybe you have staff folks who are W-2 workers for someone else, but they happen to come in and work at your workplace if you have a larger operation. So you have to be able to receive positive tests from anybody who comes in and works at your work site, because you're keeping your folks safe, and you need to know who has COVID that's coming in. and having a system to do that is important here. So we have hand washing. We also, the standard requires hand sanitizer at your locations. If there's another shortage of hand sanitizer, then the agency will recognize, look, if it's not feasible for you to have hand sanitizer, they'll recognize that and not require it. One other thing to think about is if you have suppliers or others who come into your center, then where are they coming from? And you can't necessarily track everybody, you know, whoever delivers products, where your employees come. You can't necessarily track all of it. But if someone comes from a very high hazard area, just trying to be mindful of that is something that's required in the standard. And so finally, if you happen to own your building, or if you happen to own your facility, then, and if there are other employers who are there, then you have to let the other employers know if there's a positive COVID test. Kathy, could you advance for me, please? So there are new requirements in Virginia that we haven't had before. So now for healthcare providers, and I'm not sure to what extent this is applied to you, but I'm aware that there are requirements for healthcare providers generally to let the local Department of Health know if you have a positive COVID test case. Now that applies to all employers. And so all employers have to report positive COVID tests to the state Department of Health, and they have 24 hours to make that report. I suggest you do it in writing. I suggest maybe an email or fax or something that's pretty quick, but also has a date and time of when it was sent so that you can show that you sent the report in a timely basis. There's also what's called the hotspot rule. Well, that's my name for it. And this is when you have 3 or more positive COVID tests in your single work site. If you have multiple centers around the state or around your locality, this really applies to one single location if you have 3 or more. And this is not positive COVID tests of the children. This is positive COVID tests of employees. So if you have 3 or more employees at your place, at your work site, then you have to report to the Department of Labor and Industry, or VOSH. And so there's a website, and actually you can just click a couple clicks away on the website. You can do that electronically, and that is instantaneous, and you can notify them that way. You can also notify by telephone. I personally don't recommend it because you are required to do it within 24 hours. And as a lawyer, I don't like relying on people's memories. I much prefer relying on documents, something that, okay, I can prove, here it is. I can prove that it was such and such date and time, and that you're in compliance. And then there are, and I'll get into this, there's assessing the risks for the job tasks, and that's part of your infectious disease plan, which I will get into in a minute. Could we advance, please? Okay. There's a good faith, if you act in good faith, there's a provision that if you act in good faith, that generally the agency will keep that in mind. And I think the people there are, the people at the agency are working through this as well as we are. And they have the exact same challenges, many of the same challenges we do. So there's some language there just saying, look, if you're acting in good faith and you're trying to follow the CDC guidelines and you're trying to follow the standard, that they'll keep that in mind. Now, there are also protections for employees that you'll have to be mindful of, and some of them are familiar and some are new. When I talk, when the agency talks about non-discrimination, not discriminate against someone for exercising their rights, then what it's talking about is you cannot retaliate against people for exercising their rights under the standard. So, for example, if people raise or report concerns of hazard, we're concerned about COVID, then they can express that. They can express that to you. They can express that to OSHA. They can express that now to the news media. They can even express that on social media. Those protections are in place now. The social media and news media policies, you may have policies guiding when employees can go to the press or when they can go onto Facebook and what they can say about you. That is now protected under this standard. There's also employees are protected if they want to use additional personal protective equipment. So let's say someone comes in, they have one of the respirators, and they're wearing one of those high-tech respirators, and you don't need them, and you've determined that it's not necessary. If they bring in and say, I really want to wear my respirator, then they can do that. They can wear any protective equipment they want to without fear of retaliation. There are a lot of questions about work refusals. And so if employees make reasonable work refusals and if they do it in good faith, then that's a protected activity. Now, that doesn't mean, let's say everybody on staff says, we're concerned about COVID, we don't want to come into work. I think I get 2 weeks of paid time off. We're not going to come in. That's not in good faith. Yeah, okay, they may have a fear of COVID. Like my initial point with Kathy, we all do. It's a pandemic. It's everywhere. You can't go anywhere without fear of COVID. That's not possible. What we're doing is if we manage the risk and if we are reasonable about this, and if you're taking the steps you need to take to protect them under the guidance, then they need to come into work and they can't just refuse to. So it has to be a reasonable, good faith work refusal, not just because, I feel fearful. Now if they're working with people who are symptomatic and they're not wearing face coverings and people are on top of each other, then okay, we go back and we talk with the employee, we work with them and say, okay, how can we address this in a way that makes sense? But as an employer, ultimately the employer is responsible for compliance, not the employee. So the employer is in charge here. And so you can't let the tail wag the dog. You can't let employees just say, it must be this way, that way, or the other, or we're not going to work. That's not how this works. They can't just refuse to work because they feel unsafe. Everyone feels unsafe. If you're doing your best to engage them to address the hazards in a way that makes sense under the standards, then you can require them to come into work. And if they really don't want to come into your place of work and you're complying with the standard, then I tell folks, look, maybe it's not the right place for that person to work, and that's legitimate. So that's reasonable work refusals. The employees can refuse to work, but only under very narrow circumstances, not just because they feel unsafe. Can we advance the slide, please? So there are, I'm sorry, my screen is being blocked by a chat box about the attendance. Here we go. Okay, just trying to remove that. Okay, much better, thank you. Now, there are low hazard employers or job tasks, and they're medium. Let's talk about low. Low means you don't, as part of your job, have required contact with people who have COVID, either known positive tests or suspected because of their symptoms. They're coughing and they have a headache and all that. Also, you're low hazard if you have only minimal contact with other people. I think that maybe if you have people, if you're a larger employer and you have a separate office area, and those are people who are not customer facing, they're not interacting with children or parents, if they are truly kind of set apart and they really don't interact closely with others, then they're probably minimal contact. And so there's no definition of minimal contact in the standard. The best definition I've seen is from the Centers for Disease Control, and the CDC has a 6-15 rule. If you're within 6 feet of somebody for 15 minutes or more, then I would call that that would not be minimal contact. Then again, if you say you're using social distancing, you're spacing people out, and occasionally they walk past somebody inside of that 6-foot bubble, but they kind of keep going, or if they chat for a couple minutes but then keep going, I think that probably is minimal contact. And so I don't know that you can say all employees fit low or fit medium. I think you really have to kind of see what does their day look like, who do they interact with, and how closely and for how long. If you have someone who works in a separate office, if you have someone who works in a cubicle, usually people in cubicles are at least 6 feet apart from each other. It might even have some barriers in between them. And so I would say that's probably low risk. If you're working closely with children, parents, etc., then you probably are medium risk. It just depends. And so risk is really assessed not only by social distancing, but do you have walls or floor to ceiling barriers? Can you use face coverings as part of your job? And by that I mean the cloth face covering. Can you have remote service delivery? Do you have a mechanism for people to come in, for example, with their child and to safely bring the child in, but maintaining some kind of distancing with parents or others who might bring them in? So things like that can also be factors in determining whether you're low hazard or medium. If you can accomplish those things and really keep the hazard down to minimal contact with others through those techniques, then I would say that you could qualify as minimal. And I'm glad to advise any of you after this in trying to make those determinations. I'm working with a lot of employers trying to make these determinations. Can we advance the slide, please? Now, let's talk about medium hazard. Let's advance, please. All right, so medium hazard kind of means the opposite of low hazard. Medium means you have more than minimal contact within 6 feet of other people. And so there are industries where the agency envisions that they probably are medium hazard. But again, you have to kind of go back and look at the definition of whether you have minimal contact within 6 feet of others to really make an accurate determination. So, but in the standard, there are, in school campuses, daycare and after school care, by default, the agency is saying, we really think you're probably medium unless you can prove otherwise. So I'll dwell a little bit more on medium because I think that's going to apply to more of you. Can we advance, please? So then I just provide the additional industries where the agency thinks it's medium contact: retail, stores, places where you have a tendency to interact with other people more. Advance, please. Public transportation's in there, personal care, those veterinarians. So, and you saw the child care is in there as well. Let's advance, please. So there are requirements for medium hazard employers, and this is above what the low hazard employers have to do. By default, if you can, where feasible, there's teleworking. I don't think that's possible for you unless you have an accountant or maybe somebody who can do administrative tasks from home. Generally, that telework is tough to do. You may consider staggered shifts, but I think that really staggering shifts really works probably more in manufacturing. I mean, when a parent needs childcare, that's when they need it. You can't stagger the shifts as easily. To the extent that you can eliminate personal meetings and try to go virtual like we're doing, that's something that the agency is requiring employers to do when possible. If you can develop physical barriers between people, all of this is really, okay, what you're doing is you're saying, how can I get people from being closely interacting? How do I get them a little bit more apart from each other while actually accomplishing what we're trying to do? That's really where all this is going. So for a really good example is reconfiguring spaces where people congregate. Now I know in childcare areas, look, I understand that apart from this law, you're also trying to find ways to maybe social distance, among children, and also in your normal operations. If you have a larger area, you might have a break room, you might have a lobby, you might have places where people tend to congregate. If you do, then a great way to attack on that is to maybe put those markers on the floor. Okay, you can stand here, you can stand here, and you're still 6 feet apart. And also put up some signage up either in the room or at the entrance saying, this is the maximum capacity of this room if you social distance. So just marking the floors, making sure that people are 6 feet apart and letting them know in advance how many people really can realistically fit in there while social distancing. Can we advance the slide, please? All right. Medium hazard employers. This is something that you have to kind of work through, and this is under the new standard. You have until September 26th, 60 days after the enactment of the standard, to put together an infectious disease preparedness and response plan. Now, this does not apply to medium hazard employers with 10 or fewer employees. If you have a smaller operation with 10 or fewer people, you don't have to worry about the plan. I think most of you have probably 11 or more employees, and if you do, then you have to have the plan. And by employees, I mean both part-time and full-time. So add them all together. If you have 11 or more, you're doing the plan. There's a link on the agency website with a whole bunch of resources, and Megan Healy mentioned that in the introduction. So there's a template for the plan that you can use as a starting point for your own. It's not the kind of thing where you can just kind of fill in a few things and there you go. It really does have to incorporate the true hazard assessments of your employees. Are they low hazard or medium hazard? We're back at that definition of regular minimal contact within 6 feet of others. It has to include, as I mentioned, engaging your employees in that discussion and incorporating their concerns, because and by the way, your employees, while as an employer you're responsible for making this happen and complying, your employees do notice hazards or may notice ways to deal with hazards that in ways that you may not. And so including them in the conversation, that's part of it, and including their concerns, that's a part of the plan. And so one thing to think about is also if your employees have other jobs. Now, if they have a low hazard job, that's not a problem. But let's say you have someone who, I don't know, is a nurse and deals with potential COVID infected people, or let's say you have someone who's a volunteer as an EMT on the weekends. Well, they may be working in a higher hazard area and then bringing that hazard into your workplace. I am not at all saying don't bring them in. I'm not at all saying that we can't figure out how to make that work. We just have to, in this plan, incorporate, okay, this person is bringing in additional risk. So, maybe we just have to make sure we're screening them before they come in, just to make sure that they're not ill before they come in. It might be something as simple as that. But you do have to show that you actually thought about these things. And so, like I said, I like documents. Documents help me prove a case. It helps me to prove that you are in compliance. So building that plan and putting it into writing really helps. OSHA, it's kind of like middle school math class. You don't get credit for having the right answer. You get credit for showing your work. And if you can actually show your work in an organized fashion and have that ready, then the agency will see that and say, oh, okay, you're doing it the right way, and I can tell, and I can see you put some thought into this. There's some work involved in this, but you have that template on the web, on the link. You have me, you have your association, you have each other, and so just kind of working through that, and making sure your plan is addressing your hazards. That's really the important part. I will say there are some associations that have actually had me help to take the plan and make it more adaptable or really fit with the members in that industry, so that it's a little bit easier for them to do. So then maybe that's something else that I might be able to help with. Let's advance the slide, please. So I mentioned that you have to screen people and survey them before they come into the work shift, and that's the CDC guidelines and questions. Do you have the symptoms of COVID today? Cough, headache, fever, you name it, the symptoms we've been seeing for months. You don't have to take everyone's temperature before coming in. You can ask them, do you have a fever? Some employers have said, look, we're not going to take their temperatures, but we sent thermometers home with the employees to take their temperature every day. That's a great way. But fever is only one symptom. And so, but you don't have to take everyone's temperature before they come in. And some employers have, they have a person who takes temperatures of everyone before they come in, and others even have those high-tech machines that you just look at a screen and for a second, and then it says, oh, okay, your temperature is below 100.4 degrees. But you can also just screen by asking, and it doesn't have to be completing a piece of paper or signing something every day. You can ask us, everyone. There are apps on your phone that employees can fill out, and then they can record, okay, I don't have cough, I don't have fever, I don't have this, that, or the other. And they can do that before they come into work. Or it could be something as simple as asking everybody once, and then they complete and they say, I don't have these symptoms, and I'll report if I do. And then, they self-report if they have the symptoms before they come into work. So it can be as simple or as complex as you want, but there has to be some kind of mechanism to screen employees before they come in. A really big piece of this, oh, I'm not done with that. Let's back up. Thank you. Okay. All right. I think they're telling the lawyer to hurry it up. A really big piece of this is cleaning and disinfecting. And I think some of you know something about the disinfecting part. Yeah, you're cleaning up an area, but you're using the chemicals to disinfect those that are effective against COVID. And there's a list, and it's on the website along with the other resources. There's a list that the Environmental Protection Agency has. It's their list N, and it's a list of chemicals that are effective against COVID. And so you can use that, or if you have something that's on the bottle that says that this product is effective, then you use those. You have to disinfect between shifts, and you may only have one shift to deal with. So if that might be a once a day thing. But if there's shared equipment, if there's a shared coffee pot, if there are shared tools, if there are shared workspaces, then it could be as simple as having a bottle of the disinfectant there with some paper towels, and then you instruct every employee, before you go in and touch this, because someone else touched it before you, spray, disinfect, and then touch. And so it doesn't have to be just disinfection by a cleaning service. It can also be by your employees themselves, as long as you provide the disinfecting sprays or products, and that you kind of train them on what you need to do. Okay, now we can advance. I'm getting close. Let's see, there is, of course, you have to identify and isolate people who have known positive cases or suspected cases. Frankly, you're probably getting them off the property and keeping them away until they're clear to come back to work. And so you do have to have a plan to address your subcontractors or temporary workers or other people, not just workers, but also visitors. So I think a big thing is screening. Okay, if a parent does come in, if a supplier comes in, if any visitors come in, then the same screening you give your employees, you say, hey, here's my list of symptoms. I need you to affirm that you don't have headache, you don't have fever, you don't have this, that, or the other, and that you haven't had a positive test, and you haven't traveled to a place where it's a communal spread. And so you can require that before your visitors come in. In fact, you should. And also, and I don't know that this is personal protective equipment is going to be required for you. And personal protective equipment is really more for if you're encountering people who have COVID. I think you're really just trying to get them off the property. So I don't think that there's additional personal protective equipment necessary. Now the cloth mask, gloves, you know, the cloth masks are not personal protective equipment. Really what they're intended to do is to prevent people from spreading the virus out to other people. So that's really not something that when people talk about PPE, they're really not talking about the cloth mask. They're talking about something more than that. Can we advance, please? All right, so there's a requirement to identify, you have to certify that you've done all the workplace evaluations in terms of hazards with the date that you've been in compliance from. And you also, if you are in charge of your HVAC system, your air handling, then you have to make sure, or whoever is in charge of it, they have to make sure they're following the manufacturer's instructions. And then there are certain ANSI, ASHRAE standards. There are certain specifics in that industry where that they have to follow. Your person who is familiar with your HVAC system should be familiar with those as well. Let's advance, please. This is a big one. All medium hazard employers have to do training. There is a sample training on the agency website. I don't like it at all. It's 100 pages. It's PowerPoint. If you thought my PowerPoint is bad, that one is. I don't know how many people would sit through that. But you can just kind of develop a training program that works for you in a way that works for you. And so you're just telling them about, okay, here are your protections under the standard. You can't be discriminated. You can't suffer retaliation for reporting cases. You're protected to go to agencies if you wish to do so. Just some basics in terms of what this standard is, and also what the basics guidance that's come out from the CDC that applies to your workplace. And then just show them, okay, we did our workplace hazard assessment, here it is, and we've determined that you're low hazard, you're medium hazard for these job tasks. And so here are the requirements that you'll have to follow in those job tasks. Here's what you have to do in terms of disinfecting. Here's how we're social distancing. Here's here's my masking requirement, all that stuff. So just kind of walking through that with them, that's really what the training is. And so it just has to be something that's suitable to you. If you have multilingual employees, then it has to be presented in a language that they understand. And so it may have to be done more than once. And also there's a retraining requirement. Now, the agency doesn't say when or how often to retrain, but I would say if people if they don't get it, or if the science changes, let's say there's a vaccine that comes out and people start to get the vaccine, maybe that's an opportunity to retrain in terms of how to deal with that. And we don't know what that training would look like because we don't have a vaccine, but CDC will come out with some more guidance. So when CDC comes out with more guidance that significantly changes your workplace, then retraining on that. Let's say you change a process. Let's say you change a hazard. You change something at your workplace that may change what kind of hazards people encounter. Then that's when you retrain. So just kind of use your sense, get a sense, do people know what they need to do? And if they don't, then that's probably a time when you need to retrain. Let's advance, please. Oh, okay, so let's advance through. I just add high and very high hazard. And these requirements really are if you have employees who work with known or suspected COVID cases. I don't think you really do have that. I think if you have a child or an employee who has COVID, you send them home. But for larger operations where maybe you do have, nursing staff that, and nursing staff not just dealing with ordinary stuff, but maybe encountering people with COVID, just know that there are additional requirements for high and very high hazard job tasks and when you're actually working with COVID, people with COVID. Let's advance, please. And I think that is it. Good. So I left us with plenty of time to answer questions. I'm going to do the best I can. I do have to beg to drop off at about 10 minutes before 11 if I could. But I'm here for you until that time and glad to answer any questions you may have.
Courtney, thank you so much. What a great,
Sure.
thorough and comprehensive presentation. And I especially appreciate, both Megan and your opening comments that I think helps us all recognize the great balance that these regulations are trying to achieve. So it is trying to protect employers, employees, and workers, parents, and other, customers, and especially for this business, I think it's really important to recognize how difficult it is to balance all of that. Another thing that I want to share with folks is that as we move through the questions and the conversation today, we're taking notes and paying attention to whether it would be useful for us to go to the Department of Labor and ask for industry-specific guidance and additional FAQs, the things that Megan sort of said that DOLI is trying to be prepared to work with specific employers and industries. And it seems that there are going to be enough specific questions that probably would be prudent for us to do. But I think also, Courtney, just your experience and depth really helps us tease out, what are the, the areas that we are most interested in getting specifications about. I think also just recognizing that these regulations will be also moving through a process over the next several months, and and recognizing that we're all living through this experience together and trying to figure out how to make it work as well as possible for the particular purposes that they've been developed. So Courtney, I'm going to go back through, and I think I'm going back to the beginning. You've had some questions coming through from the beginning of your presentation, and I'm going to hit on a few of them. And just for your info, we'll be kind of starting back from the start. And then we'll take a few questions, and then we'll bring in Jenna Conway, because a number of the questions are really related to kind of the overlap with the Phase 3 childcare guidance. And so we'll take questions that may be more specific to your information first.
Okay.
We did have one initial question for confirmation purposes. If your childcare business is singularly owned and operated with 0 additional paid staff, your business does not fall under DOLI jurisdiction. The writer says, I contacted DOLI directly, and that is the information that was given. I think, if you could answer that, and then also touch on for those with 10 or less. You said that they don't need to worry about the plan. I want to make sure that, we are clear about, do they need to worry about, teasing out what their plan is, but not necessarily submitting it to the Department of Labor or have it written. If you could just respond to that, that would be very helpful. I think there are a number of folks on the line who that would apply for.
Sure. So if you're a sole proprietor, then no. If you don't have employees, then no, this does not apply to you. And then, and of course, you do have separate guidelines that apply really more to childcare that are outside of this agency's jurisdiction. And so, yeah, and so there's there's 11 or more employees that do have to do the plan and also do the training. And so then if you have 10 or fewer, and if you're medium hazard, then you're out from doing the plan. And also lower hazard doesn't have to do either. So yeah, does that answer all your questions?
I think so. I'm sure we'll see in the question box if not.
Sure.
Next question. Early on, you talked about the types of workplaces, and you mentioned most private sector. Does that include religious institutions, so church-based childcare programs?
Yes, it does.
Thank you. Let's see, the next question is, let's see, somebody had asked when you were talking about the testing and notification of positive cases, do positive test results have to be in writing?
Oh, you know what? It doesn't require getting that in writing. It just requires if you are notified of a positive COVID test. So if an employee tells you they got a positive test, then the way this standard is written, it does not require that you get it in writing.
Thanks, Courtney. Next, the standards define childcare as a medium risk task under the assumption physical distancing of 6 feet can be maintained. Since it's nearly impossible in the childcare environment to keep pre-K kids 6 feet apart at all times, does that lack of physical distancing raise the task to high risk?
No. Medium risk is defined as more than minimal contact with others within 6 feet. And I use the 6 foot, 15-minute rule. And of course, that's impossible to do with little kids. And plus they probably are not masking it up like the adults are. It's just the reality. But no, high risk, it really is about contact with people who have suspected COVID cases. And I assume if you have a kid with a suspected COVID case, you're not letting them in.
Thank you. Next, there are a couple of questions around the work refusals. What is defined as reasonable work refusal? That could be very broad and abused. And then another person asked, what are examples of reasonable work refusals?
You're right. The definition is broad, and ultimately, the standards don't necessarily give us great guidelines in how to interpret these terms. A lot of them are vague terms, and they just have to kind of get, oftentimes through the courts, we define what these terms mean. What does good faith mean? What does reasonable mean? So I would say, and this is in my judgment, but then again, I'm not a judge. And ultimately, these things are decided by judges, and they decide them on the facts of a particular case. But if you have a bunch of people saying, we don't feel like working, this is unsafe, we feel unsafe. Well, guess what? Everyone feels unsafe. So, and that kind of goes to our earlier conversation. We're trying to manage the risk. We can't eliminate the risk. And so I feel unsafe is not necessarily a reasonable concern. If they can point to specific circumstances, look, I have 3 kids who are coughing their heads off and either right on top of me. Okay, well, that's probably a reasonable, good faith concern, and also one in which you have that conversation with the employee and say, okay, let's talk about how we can address this. Do we take a look at our policies in terms of who's coming in here? Are people flouting our rules in terms of symptoms and they're coming in anyway? Can we develop more distance? Whatever it is, and just engage them. And so I'm not saying you can cure every problem, and certainly you're not going to keep, kids from being close to adults. That's not going to happen. But you can address ways to try to reduce the hazard. And so reasonable, it really kind of is, it is very situation specific, but it really just kind of depends on the circumstance. If you feel like your employees are trying to get away with one on you, and they just don't want to come into work and they want to get paid anyway, no. And so a lot of employers, a practical solution for you is, they're saying, look, if you feel unsafe now, okay, you don't have to let them keep their job. You don't have to. But if you wanted to, a lot of employers are saying, well, okay, we're going to have you on unpaid leave until such time that you do feel safer. And then we'll bring you back on the terms of how we are doing safety here. And so that's a practical way of approaching the issue, but there are other practical ways of approaching it as well.
Okay, thank you very much. Our centers in a church and other groups such as AA meet in the church. They use their own spaces, but we do cross paths. Is there any requirement for being notified if they test positive? How would you recommend a center like this dealing with the regulations in an environment where they can't, completely have sort of boundary walls of risk?
If who tests positive?
I think that they're probably referencing the individuals who are part of the other groups that come into the church space.
Right. You do not have a reporting requirement under this standard if there are non-employees who have positive tests. And that includes other visitors, maybe members of a church if you're at a church-based facility, or the children you're caring for. This standard does not apply to that. This standard applies only if you have employees of yours who test positive.
Thank you.
Mhm.
Do substitute teachers count toward the employee count for 11 or more to make the preparedness plan?
Yes. And so I think you're probably talking about a part-time employee, someone who comes in from time to time. But and also a lot of people, and this is a whole different discussion that we can talk about for at least an hour and barely skim the surface, is what an employee is. But a short rule of thumb is not just people who are your W-2s. If you are controlling a person's schedule, if you're keeping their time, if you can direct their activities, if you provide any equipment or whatever uniforms, anything that they need, or if you're controlling someone at your workplace, even if you 1099 them, there's a good chance that person could be considered an employee under the law. So don't just use W-2 or 1099 as your guidance as to whether someone's an employee or independent contractor. So if you control someone, especially their schedule and exactly how they do what they do, the law is probably going to regard them as an employee. And then they'll count toward your count under that standard.
Thank you. Now, Courtney, I'm going to read a question or a comment that's fairly lengthy, but I'm going to read it because I think it highlights for us the gravity of some of these situations for childcare employers. And he writes, our profession as well as our own livelihood is at risk. As you all know, COVID-19 has decimated our programs. The state guidance regarding COVID-19 cannot be feasibly adhered to as written. As a result, some providers have remained closed, myself included. Others have answered the call to remain open to support our families. Some have no choice but to remain open as the livelihood of your family is at risk. In all situations, I directly support your decisions. For situational awareness, he's provided some of the steps that he's taken for his program. And one of the points that he makes is that he had reviewed line by line and word by word the state and CDC guidance, then contacted the Department of Social Services and determined that if he knowingly operates and does not adhere to the guidance as written and an outbreak were to occur, he could be charged with child endangerment, if not mistaken, a Class 6 felony. I think, these are some of the concerns that providers have, and really the level of gravity that they, take these issues about, and, leading to some of the questions that I raised with you earlier and with Megan about liability. Anything that you want, any way that you can react to that sort of concern.
I hear you. I do the best that I can to represent employers. I will say that I was on the board that did pass the standard. I will say in all candor that I opposed the standard because I do think that employers following the CDC guidance and doing the best they can was probably the best system. And so, but my voice was not the majority. And so a majority of the board did pass the standard. I did what I could to suggest amendments to make it more workable. In a few cases, I was successful. In most cases, I was not. And but I do think that your association, each of you, as the agency is considering a permanent standard, they need to hear your voice. So Megan Healy, who was on before me, the administration, the members of the board that passes regulations, the board I serve on, we really do need to hear from you, because I do think, unfortunately, that many of the voices of employers were not really, there was no public comment period. It was just kind of done fairly quickly, and the 14 members of the board who wanted to pass the standard as it is really wanted to push forward. And I did try to put the brakes on a lot of this, but I was not successful. I only have one vote. And that's not helpful to you, but it just lets you know that unfortunately this is a process that sometimes employers' voices are not heard. And this is one where employers' voices were critical. And so the best that I can do right now is to take my board hat off and put my lawyer hat on, and then try to advise and represent you in your compliance with this and make it as workable as I possibly can. I can't offer all of the solutions you need, but I'm going to do the best I can to try to help you to be in compliance in a practical way, and to make your case to the agency that, you know, look, they need to embrace the reality of what you deal with.
Thank you. Appreciate that candid response, Courtney. And I'm looking through some of the additional questions or comments that have come through, and it looks like there will be, you know, a strong push and a lot of motivation for asking for some industry-specific guidance from the Department of Labor. I'm going to ask you one more question, and then we'll turn to hearing comments from Jenna Conway. And we recognize you'll need to jump off by 10:50, but we may have some additional questions for you after that. What agency is responsible to ensure compliance? Can you talk for a few minutes about what you anticipate about enforcement and compliance over the next several months?
Right. So the Department of Labor and Industry, and VOSH, Virginia Occupational Safety and Health, within the Department of Labor and Industry, enforces this. And so what they do is they'll send an inspector. If they find violations, they'll issue a citation. That is not in the criminal context, like the last question was asking about, which is not to say, so there are criminal laws and there's civil liability. That's not what this agency does. What this agency does, it issues citations, and then there's a process, an administrative process, when you can contest the citation. And you can even take it to court if the agency is wrong, which, by the way, happens. So there are times when the agency does not have it right, and this is new turf for them. And in fact, the agency right now, they're meeting with each other to try to train each other on the standard, because I've heard from folks inside the agency that internally they don't know what the standard always means and how they're going to enforce it. The agency right now is not sending inspectors out into the streets and out to workplaces a whole lot. And I don't think they're going to do that. They're concerned about COVID like anyone else. They have they're just kind of hanging back, and they're issuing, they're enforcing by fax and phone, and they're letting employers know through a hazard alert letter, look, we think there's a hazard here, how are you fixing it? And I draft a lot of replies for people, just responding to these inquiries and letting the agency know that we're in compliance and here's why and here's how. And that's why I asked to have those documents ready to go so that I can defend you to the agency. I think that now with what I call the hotspot rule of 3 or more positive cases of positive employee tests, let's just say that you don't go to the refrigerator unless you mean to eat. I think that provision is there so that the agency can identify what it calls hotspots, and then to pay special attention to those employers. And so I do expect to see more activity there. But I just talked with a regional director who said that they're still trying to hold people back from going out into the field as much as they can.
Courtney, I just want to thank you so much for bringing us so much great information and perspective. And if you can stay on and hear Jenna's comments, that would be great. But we will understand that you need to drop off at some point, and just want to go ahead and thank you so much on behalf of all of our attendees, in case we don't have a chance to talk with you again before you drop off. But I'm sure we'll be following up with you on a number of these questions.
Sure,
And
thank you.
That, thank you so much. Jenna, if you're ready, we'd love to hear your comments now.
Excellent. Can you hear me, Kathy?
Sure can.
Excellent. Good morning, everybody. I'm Jenna Conway. I'm our Chief School Readiness Officer. It's great to have so many attendees this morning. As many of you may know, I work very closely with the Department of Education, the Governor's Office, and the Department of Social Services, tackling how we can assure that all kids have every opportunity to enter school ready, and really working kind of across sectors, family day homes, child care centers, our faith-based programs, as well as our Head Start and Early Head Start and our pre-K programs in the schools. We've taken a broader focus of late as we're also thinking about supporting virtual learning for school-age children, and we know that there's a lot of information, high levels of stress, and just want to take a moment to recognize all the incredible work that folks on the phone have done to keep kids, educators, and families safe over the course of the last 5 months. I do want to note that the efforts that you all have made and put in place, a lot of which is that you're already doing in terms of what's included in the DOLI standards, you are paying off. When we look at, if you go to the Virginia Department of Health website and you look at the outbreaks dashboard, you look at educational settings, which right now includes child care, K-12, and higher education, although we are planning to break out those separate settings, that we have, I believe as of today, only 39 outbreaks, involving just over 160 cases or so across the state. And when you think about that, we've had 3,000 providers open in between the child care, family day homes, the hundreds of thousands of kids that have been served. Your ability to keep those numbers that low really speaks to the almost immediate stepping into action, complying with the myriad federal, state, and local guidance, changes in regulations, information, and this rapidly shifting pandemic, and just want to take a moment to recognize that. Sometimes folks, say, well, those numbers are low because, folks, kids weren't in school or programs weren't open, and we very quickly correct them and say, actually, childcare has been open throughout the duration of this pandemic on the front lines of serving our kids and families, and it's because of the practices that you put in place, the screening kids, the communicating with parents about the importance of not sending kids to school or to childcare, sick, the conversations you've had with your staff about how we're all in this together and making sure that they're not coming to work with any symptoms, or they are letting you know if there are concerns there, your attempts to put distancing in place, where we, as I think Courtney alluded to, where we have to use words like where feasible and when possible to address the developmental needs of kids, and knowing that you can't change a diaper from 6 feet away and you can't give a hug from 6 feet away. And so as well as I think wearing facial coverings, particularly our staff, and just really being extremely thoughtful about every aspect of your operations. I imagine for some of you, it keeps you up at night. You probably wake up in the middle of the night and like, I should do this thing to make it even that much more safer for my kids or for my employees. And thanks to the extent of the work that you've done, again, 39 outbreaks, all of which are not even in childcare, is just really incredible. An outbreak, for everybody to understand, is 2 or more cases affiliated with the same site. So we know that there have been more cases, right? Folks might get it at home in their communities, but in terms of places where there's a potential likelihood of it kind of being connected to a site. Those numbers are very low because of the things that you have put in place. I want to kind of get to questions quickly. I wanted just a couple of overall observations, and hugely appreciative of Courtney and the work that has gone into the presentation, very thorough this morning, and recognizing that this is a balancing act, right? I think kind of trying to figure out how do we make sure that we can have open programs across the state that we address some of these concerns about safety and liability. On the other hand, wanting to protect this workforce, right? And as you all know firsthand, that this is a majority of women, significant number of women of color who work in this workforce, and really trying to sort of strike that right balance between making it possible to work and not, sort of forcing employers to take on too much risk, but also being cognizant of how COVID-19 has impacted communities of color in the Commonwealth, right? Disproportionately, our African American and Latinx families and communities, are more likely to get it, more likely to have serious health effects, more likely for it to have, sort of to be fatal. And so really trying to kind of be extremely thoughtful about how we handle that. I should note to that effect, however, that our dashboard also shows that there have been 0 deaths affiliated with any of the outbreaks in Virginia when it comes to the educational setting. So again, huge kudos to the work being done by you every day. And I echo Courtney's point around this is a back and forth process, and encouraging folks to reach out to Megan Healy and others, right, to kind of articulate these concerns before these standards, become permanent, and as we are kind of grappling to figure out, this best balancing place, right? I mean, there's not a lot of sort of easy decisions these days, not a lot of easy choices, but I think hearing from you as we go to put these in place and understanding, where this does and does not work for the industry is important. My other just kind of high-level observations, having been on these conversations for the greater part of 5 months, are, really the kind of importance of having and communicating a plan, right, which I think is required if you're above a certain size, according to the DOLI standards, encouraged by the CDC, but is part of what I've heard from people is most important in keeping people, all of your staff safe, is just really making sure that folks aren't bringing cases to your center, right? And so making sure that families, that your staff, that everybody understands the protocols, everybody is extremely aware of the symptoms, everybody kind of recognizes the value of open communication if you think you've been exposed, thinking about how we allow for folks to quarantine or have time off to go get tests, and really that kind of that clear communication, as Megan described in the beginning with her own child center, is just so essential. I think we've seen that is also particularly important for all of our summer day camps, which have larger numbers of school-age kids, where it's very difficult to maintain the distancing, and and they just really speak about the sort of the change in routines, and being almost religious about those change in routines, and having all of the parents and staff deeply understand those routines is really important. And so, yes, training is a requirement of this, but I think what we've found that works best is just continual communication with staff and with families, constant reminders about the things we're doing to keep each other safe. The other piece, and I appreciate Courtney's clear-eyed guidance on some of the questions that have come up, is there is some ambiguity here, and even in reading some of the questions, right, where there's a lot of use of the word possible and feasible through the DOLI guidance, in the CDC guidance, and in the DSS guidance. And, I noticed in the CDC guidance alone, there's 16 times they use the word possible, right? 6 times in the VDS guidance. In the DOLI guidance, the word feasible is used 14 times, right? A lot of times in relating to things that you've asked the most questions about, including things like distancing, right? And that is challenging. Again, it represents this balancing act between, we know that the context is different. We know that, kids are kids, right? Infants are infants, toddlers are toddlers. And so so much of this guidance is really kind of where feasible. And that, I think, to Courtney's very sort of smart point, like part of this is you have the plan, you document it, you document how those decisions are made, right? Like how I sort of work with my teachers to understand, where are the points where they obviously have to go, fewer feet or where it's not feasible, so that there's a paper trail to kind of protect you and to protect your employees. But I just want to note that the fact that all three of these forms of guidance have the word feasible and possible mentioned multiple times, really, reflects, the fact that some of this is your discretion. And we know that makes folks uncomfortable at times, but that is, we think that's really important, so that you're, that where there is feasibility, where there is sort of flexibility, as Courtney described, right? We sort of, in terms of the CDC, that we keep that there. And then the last piece of this is, I think the figuring out, how we continually offer the guidance and supports that are more customized to the sector. And so I echo Kathy's point, and sort of thinking about, is there a way to sort of pull out? It seems like, there's a lot of stuff in DOLI about high risk, right? Which, as I understand from Courtney and from the interpretations I've heard, not relevant, right? We're really talking about sort of medium risk is probably the safest kind of assessment, and really thinking through, okay, well, in that context, what are the most important pieces of DOLI? How do I focus on that? Because it's, it's a lot of information, and what are the sort of, whether it's a plan template, whether it's a PowerPoint to support you with training, certainly willing to kind of to echo up to the powers that be, that could be very useful for the childcare and family day home sector. So with that, Kathy, I will turn it back to you and take questions.
Thanks so much, Jenna. Appreciate that. And I think, just hearing your comments and seeing some of the comments and questions that have come in, I think we're, we just have to recognize that we are, grappling with some issues where, there's just a lot of ambiguity, and it's really hard to get down to clarity. And also, I think we're balancing sort of responsibility too. And I really feel for the employers and the providers who are, doing their best to meet guidelines, to make their, workplace safe for not only themselves, but for their employees and for the children and families in their care, but also try to pay attention to, how that balances out or relates to what the guidance and mandatory requirements are. So it's, I just want to acknowledge that this is all a very difficult balancing act, and there unfortunately are no clear, or very few very clear answers. Also, a lot of folks have asked for links to some of the resources and web pages that have been mentioned throughout. It seems that there may be a link or a page on the DOLI website that is apparently broken at the moment. We'll look into all of those things and try to send in our follow-up email links to the resources and to the pages and documents that have been referenced, as well as a copy of the slides and a recording of the briefing following our session today. So Jenna, let me look at a few of these questions that have come forward and see. First, I will see if you want to also address, I pitched sort of a lengthy comment that I think raises the recognition of the level of importance and significance for providers about compliance and liability, and just wanted to see if there was additional comment that you wanted to make about that.
So I think, I think there is the kind of the key challenge, right, is, and I know Courtney alluded to this at the beginning, right, is sort of one's comfort with risk, knowing that if language like when feasible or if possible, then shifts that decision for how much risk you want to take onto, the individual organization or proprietor. And everything that I understand from talking to public health experts is that they want to provide that context. They want to provide the flexibility that a lot of what came out of the CDC as it relates to childcare in schools is in recognition of the age of kids. I think the sort of DSS specifically added the point that I noticed Jen raised about kind of developmentally appropriateness. And if you look at that side by side with DOLI, right, I mean, they basically say feasibility is defined as sort of, financially and operationally feasible, right? And I think in the operation of childcare, right, to use the technical terms, like you're dealing with small kids, right, who need to be changed, right, who need to be hugged when they fall down, who need to have a Band-Aid put on their knee. And so, you could see it both ways, right? I mean, I think it's there is enough alignment between the DOLI and the DSS guidelines, but it doesn't sort of, there are parts where it does leave it up to folks' discretion. And I think as we have seen programs come back on, I think we are seeing varying levels of comfort with that. There are some folks who have been operating in this space since March, and I think are at a place where, okay, I understand how to, to work with my staff to sort of have that discretion. I feel like I have enough written down in terms of our procedures and policies. I've had enough conversations with my staff and with my families. I've walked around and observed what is in place and feel like, we are complying so that, this would represent good faith. But as Courtney, our attorney, kind of the attorney on the phone alluded to, a lot of this is discretionary. And so I think some of his very practical points are really key, right? Thinking about, you document your plan, even if maybe you're not required to have a plan, right? But you sort of document that. You document how you engage with your teachers, right? You document how you as a director do a walkthrough and check on that, right? You document kind of when you make the phone calls to your local Department of Health to ask them a question, or when you send an email to the state. And, none of those things give one 100% immunity, but they at least represent an effort, right? And could be argued kind of in quotes, a good faith effort to follow these guidelines, and so that you're doing everything you can to keep kids, your educators, and families safe. And so I think that's the take. I think that when we go and speak to our colleagues in the Attorney General's office, the answer is, well, everybody should talk to their attorney. And we think that's kind of a limited answer. We're glad that there was an attorney on the webinar this morning. We know that, not everybody has an attorney in their back pocket. I certainly don't. But I do think those practical tips that Courtney has provided this morning on, even if it's in a little notebook next to your desk, or you're sort of, you're emailing things out and keeping a record of that, is important in terms of demonstrating the effort that you're making. And that, we can't, it's a pandemic and there's no possibility of zero risk. And so kind of recognizing how do we balance between clear guidance, but that also offers some discretion based on the work that you do.
Thank you, Jenna. And I'll see we're 1 minute away from our close time, but we have many, many more questions and comments. I think that some of the comments that I'm seeing and questions that most concern me are that these, most recent regulatory standards and the, assumption of the need to comply with them is really forcing many programs to rethink being able to stay open and operating. And I think that's kind of exactly the opposite of what we all want. We really want these programs to continue to remain open and serving especially our most vulnerable children. So we definitely, will want to have some follow-up discussion about this. We'll pursue some of the industry-specific information and try to get some answers to some of the additional questions on the box. But Jenna, as always, appreciate your coming on board and sharing your thoughts. And we'll just, I'm sure that you may want to have some additional thanks and gratitude to the providers on the phone before we let them get back to their day, but we'll let you have the last word.
Wonderful. And and I just, I think, Megan started out with her appreciation. I think Courtney noted, right, for his kids, and even now, but even remembering back to when they're in childcare. And then many of you know that I'm also the parent of very young children. But, you know, again, we want to recognize that you all have been open and doing this work, and we certainly, as Kathy noted, do not want to go backwards, right? I mean, in many ways, you know, maybe Virginia was the first state to have these labor standards, but what you all have been doing in practice over the course of the last 5 months, you know, has been ahead of the curve. You figured out before schools, before higher ed, before anyone else, how to be able to serve infants, toddlers, preschoolers, and their school-age kids in settings, how to keep them safe, to keep your educators safe, and to keep families safe. And that's demonstrated in what the information we have on outbreaks in your settings. And so I think it's really critical that we continue to work with you to figure out this balancing act on how do we keep the guidance and make sure that there's consistency to protect some of our most vulnerable members of our workforce, including our child care educators, but also ensure that we can enable you who've been successful to continue to do what you've been doing. And so that's a really important piece, and one that I will carry forward, in addition to just expressing my deep, heartfelt appreciation for putting yourself on the front line, putting your employees on the front line, and continuing to serve Virginia families and children.
Thanks so much, Jenna. We also appreciate Megan Healy and Courtney Malveaux for their time today, and all of the attendees. And we'll circle back with more information soon. Thanks, everybody, and have a great day.